Right after your arrest, there's no requirement for ignition interlock device for it to be installed in your car or cars or anything. It works like this. You get arrested, you get cuffed, you go to jail or wherever, they give you a court date. And then what happens is you hire the best attorney you can, who shows up for the court date, takes care of that for you in most cases. And there may be some requirements from the court. You might have to do some AA meetings or something like that while the case is going on. Every once in a while, in a more extreme DUI situation, they might want an ignition interlock device on your car for you to keep driving, but that's pretty rare. Typically, only once the case is over, and if you get convicted of a DUI, in order to be able to drive again, would you need an ignition interlock and IID installed in your car, and then you'd have to get an ignition interlock license from the Department of Motor Vehicles in California as well. Basically, if it's a first DUI and you're convicted in court, you're looking at either 6 months of no driving or 6 months with an ignition interlock device in a car, and that's the only car that you can drive. It has to have an ignition interlock device in it. Or you can go 1 month of zero driving, full suspension, followed by 12 months of work-restricted driving, and that's to and from work and work-related driving. It is up to the court, though, if they want to require the ignition interlock device and not allow you to get a work-restricted license. They can make that statement. They usually don't in most counties. It's definitely not in Marin County. They don't do that. It's up to the actual defendant or the person who's been convicted of a DUI. So the answer is no, you don't have to get an ignition interlock device as soon as you get arrested. And what you need to watch out for is you're going to get these solicitation letters that will say, hey, you need this, and it'll look like it's from DMV. It's not. You get companies that will call you up and they'll say, hey, we'll get you driving again, but you can drive. So when they say, we'll set a hearing for you with DMV or get your ignition interlock license, or we'll walk you all through this and just pay us, a smaller amount of money than it would cost to hire a lawyer, big mistake, because they're misleading you. They're not lawyers, and you're just giving up all your constitutional rights right away by giving up in the beginning. And then timing-wise, you may end up having longer suspensions listening to someone like that. So when they call, hang up the phone and make sure you call the best DUI lawyer that you can in Marin County.